Last June, the U.S. Supreme Court overturned Roe v. Wade, the landmark piece of legislation that made access to an abortion a federal right in the United States. Protests happened, and many wondered what would be the future of reproductive rights in the country. But others were also questioning the way the Constitution could be reinterpreted once more. As time has passed, the members of the Supreme Court have changed. But society has changed as well. So the question that arises is, should the Constitution serve society as it is today, or as it was back then? In order to answer this question, for Democracy Week, the Albert Hirschman Center on Democracy was delighted to invite Professor Peggy Cooper-Davis for a short discussion.
So we have with us Professor Peggy Cooper-Davis today here at the Graduate Institute. So welcome, Peggy.
It's a pleasure to be here.
So you joined the law school in 1983.
Well,
I think.
you have it written down and I have no memory, but yes, that sounds about right.
It sounds right, yeah. And you had been earlier very engaged in the practice of the law for more than a decade, if I got it right, including serving as a judge of the Family Court of the State of New York. Since then, you've become a prolific academic writer, if this expression makes sense, with an extensive scholarship in various areas, from the inquiry into cross-racial interactions within the legal system to the analysis of judicial reliance on the social and psychological sciences, which are critical, you claim, for making decisions on child placement in family law and on matrimonial disputes. You even published a collection of essays exploring the implications of Carol Gilligan relational psychology. But more recently, I think your critical opinion about the reversal of Roe versus Wade, the 1973 Supreme Court decision holding that women have a constitutional right to terminate an early pregnancy by the same court in the case of Dobbs versus Jackson, has reopened all this important debate about the meaning of constitutional amendments after the civil law and the contestation surrounding the American Constitution itself. So could you please tell us more of it about this debate and why overturning abortion rights ignores freedoms?
Yes. Well, it's a complex story. I'll try not to make it too complicated. But the justices of the Supreme Court over the years have taken different perspectives on our Constitution and on the meaning of our constitutional language. And at the moment, we have a majority on the United States Supreme Court that is very committed to recognizing only rights that were traditionally and historically recognized, even as far back as Reconstruction after the Civil War and some farther back than that. Whereas more progressive justices feel that the general language of the Constitution can be more broadly interpreted and can be interpreted in light of how we feel today about things and how the society is today. So that's led to a great tension. You mentioned that I had been speaking recently about this controversy, but the truth is, sadly, I began in the 1980s saying that understanding the human rights provisions of our Constitution required understanding how much it was changed after the Civil War. And my argument is that the government after the Civil War was operating according to an anti-slavery ideology. And it, for the first time, defined citizenship in the United States and it granted in general terms the privileges and immunities of citizenship, and it guaranteed, as against both the federal government and the state governments, that people's lives and liberty and property would not be affected unreasonably without what they call due process of law. Now, my argument has been that that revision of the Constitution should be understood as the anti-slavery move that it was, as incentivized by anti-slavery sentiment. So, for example, whereas women who had been enslaved were literally subjected to breeding by their owners, women who were free and free citizens should not be subjected to such things and should have a certain amount of autonomy, should be able to act as free citizens. And that's a progressive understanding of the Constitution. But without it, the court is now forced to say, well, lots of people disapproved of abortion 200, 300 years ago. And so it's not a part of our history and tradition. And so they have overturned the decision that granted women the right of choice. And we fear that other decisions will be overturned as well.
So I think, I'm very interested in the last part of of your analysis, because it seems then that the overturning of Roe has an impact beyond abortion, and therefore it has a connection to all the doctrine about, original interpretation of the Constitution, which in fact is a doctrine that essentializes a meaning of the nation and a meaning of...
It locks it in the past.
Unlocks, the legal interpretation of basic constitutional rights into the past. And at the same time, it's interesting to think about the relation between these two different narratives that you explained yesterday about the Confederate narrative and account of civil rights, which is linked to then the posterior, failure of a conception of anti-slavery constitutionalism. And so it goes beyond the originalist interpretation, but it also links to a certain ideology of supremacy and exclusion.
It does in an interesting way. The question becomes, how much change did lawmakers and the people who voted to affirm these amendments intend when the Constitution was changed after the Civil War? And on the one hand, people who want to remain true to the anti-slavery ideology say that the change was radical and important, and that the federal government was given power to protect human rights that it had not had before. On the other side, you had people who had been allied with the Confederacy and people who were deeply devoted to the independence and the rights of states, because they thought states, for example, should be able to decide for themselves whether people could be enslaved. It wasn't the business of the federal government. So they have evolved what my colleagues and I call a Confederate narrative. And it's a narrative in support of the former Confederacy. and it says that the Civil War was not an uprising against slavery, despite all of the black and brown people who fought against slavery in the Civil War, but it was rather a technical dispute among brothers. And the people who drafted the amendments were all caught up in the fervor of the war, and they had a tendency to go too far. And so we can't take their language too seriously. We have to interpret it conservatively, and we have to assume that the structure of our government was changed as little as possible. And so, whereas the progressive view is that the federal government was given a great deal of authority over human rights after the Civil War, the conservative view is that, no, that was too hasty, and we should pull back. We shouldn't allow that. And the states should remain free to do as they choose.
But that this acknowledging of the diversity of the states in the sense of defining what is the meaning of constitutional rights, to a certain extent also involves recognizing some form of majoritarianism in the definition of rights that could have an impact on the protection of minority rights, and therefore movements like Black Lives Matter and all these movements in a sense react towards the implementation of a populist understanding of the Constitution and the implications for the rights, especially the rights of excluded or marginalized, oppressed groups.
It is controversial whether federal protection of human rights is better for minorities or state protection of human rights is better for minorities. And there are good arguments on both sides. But historically, this argument for state protection has always been an argument in defense of slavery and caste systems and discrimination in the United States.
Okay, so thank you very much, Peggy, for answering these questions, and thanks.